Aishvarya Singh, a 28-year-old attorney and director of a law firm based in Queensborough, in Durban. She holds her LLB degree and recently submitted a dissertation in pursuit of Masters of Law in International Law through Liverpool John Moores University. Her practice covers a broad range of matters, including family law, criminal, civil law, as well as wills and estates, labour and corporate advisory. So she's passionate about making the law more accessible. Good morning. Welcome to the Breakfast Rush.
Good morning. Thank you.
Oh, wait, hang on. Let me do this. I'll put your mic on. Good morning. Welcome.
Good morning. Thank you so much for having me on this morning.
It's a pleasure. Thank you for coming in. Altaf says that you're the person with the knowledge on the subject. So let's start right at the very beginning. Why is it important to have a valid will?
Well, it's basic. We have a lot of stuff. We value our items, our money, and a valid will gives you the power to control what happens to your estate when you pass away. It allows you to leave your assets to the people you care about. So whether it's your children, your parents, your spouse, even relatives like nieces and nephews, you decide on who inherits and on what terms.
Okay. What makes a will valid in South Africa?
So for a will to be legally valid, there are some requirements under the Wills Act. Firstly, you have to be 16 and over and be a competent person at the time of signing your will. Your will must be in writing. The testator, the person signing the will must sign at the bottom of each page. It all gets very technical, but anything that deviates could invalidate your will at the end of it. You have to have 2 competent witnesses. That means someone over the age of 14 signing, and they must also sign each other's presence. And these witnesses cannot be beneficiaries. That's a major issue we see with DIY wills. That witnesses are also the beneficiaries of a will.
Wow.
Yeah. So it's possible to write your own, right?
It is possible, but from a professional standpoint, not advisable, because even a vague clause in your will or contradictory clauses can cause some problems later on, can invalidate it. And if your will is declared invalid, your estate is administered in terms of the Interstate Succession Act, which means that you don't decide who your money goes to.
Correct,
the law does.
There you go. So for married couples, is it better to have a joint will or separate wills?
So South African law allows for both. You can have, if you're married in community of property, especially, obviously your estate is a joint estate. When one spouse passes on, the estate is split in half. The one spouse retains their half. The other half is determined in terms of the estate. A joint will is advisable as well. You can also have something called a mirror will of sorts, where a joint will say, I leave my half of the estate to my spouse. Should my spouse pass away within 30 days or predecease me, I leave it to secondary beneficiaries, which would be your children and such. So each spouse will sign that and leave it to each other, then to secondary beneficiaries, and that's your joint will. Alternatively, the mirror will is just 2 separate wills, basically with the same terms, except the secondary beneficiaries can be changed. So, there are different types of marriages with, children from previous marriages, that sort of thing. So it can be advisable. It depends on your circumstances in that case.
What exactly does an executor do, and why is it important to appoint one in your will?
Okay, so an executor is a trusted person usually that you appoint. You have to obviously discuss it with them. It's advisable to tell them they're going to be the executor of your estate before you entrust them with that. It's the person responsible for administering your estate after you pass. So once they're appointed through a process by the Master of the High Court, they get issued letters of authority or letters of executorship. So it gives them signing power basically over your estate, and they handle everything from start to finish. They access banks, SARS, everything. Yeah.
So in essence, they take charge of the entire process basically from start to finish.
Yes, essentially,
and
at that point.
And that person cannot be a beneficiary?
The executor can be a beneficiary. It just, a witness cannot. That's determined by the validity of the will and such. So,
all right. So what's the process for reporting a deceased estate?
Okay, so in terms of the Act, the Administration of Deceased Estates Act, we should be reporting estates within 14 days of the person passing on. Unfortunately, with certain issues, that doesn't come to pass, but it is advisable to do it as soon as possible. You would need to, obviously, it is best in most instances for an executor who's a layman to consult with a professional to attend to these, because there are a lot of forms and technical aspects to be dealt with that can be overwhelming, especially in a time of grief and such. You have to have the death certificate, original will. You've got to have a set of documents that are prescribed by the master's office filled in properly and submitted, and thereafter you're issued with letters of executorship, which then kickstarts an entire other process to settle the estate.
Can a family report the estate on their own, or should they use a lawyer?
So it is possible, very possible, to report it on your own, but again, you have to consider the administration of it. There's a lot of legal paperwork to be drafted, and these things have to be drafted a certain way. One thing that could be missing from your attempt at reporting an estate could cause delays, and if there are delays in reporting an estate, you obviously cannot start dealing with the estate itself. So it is always advisable to consult with a professional or someone who has experience in doing estates.
So listener sends in a question, and I'm not sure whether you're in line to answer this one. Why does it take so long to get the executive papers?
Unfortunately, that has to do with the capacity of the master's office that you're reporting it to. We take every steps to submit it as soon as possible, but they truly cannot get to something unless they have the time and the manpower to get to it quickly. So there is a waiting period. Estates can take up to a year to finalize.
What would you say to someone who thinks they're too young or don't own enough to need a will?
So that's a common misconception. As long as you are earning money, if you have bank accounts, if you have a car, if you have anything truly, it is always best to just have a will, even a simple will in place. It makes things much easier later on, especially if you feel like you don't have a lot of assets, but you have minor children. You need to have a will in place providing for it as well. Tragedy doesn't discriminate by age or wealth or anything. It's just best to have your affairs in order so that you have some peace of mind in these situations.
If you just tuned in, we're speaking with attorney Aishvarya Singh with regard to wills and estates. Another question that comes in from a listener now is, what happens if the attorney is the executor? Is that safe?
That is safe in some instances. I have seen many instances where attorneys are appointed as executors. But obviously in that case, you have to trust the person you're appointing, and attorneys are obviously perfectly suited to handle these matters. So they bypass the step of having to get the executor themselves to sign it, and they can sign it themselves and submit. So it can speed up the process, but it obviously depends on the circumstances, the attorney, the family, and how happy they are with that situation.
So then the question becomes, is there an executive fee?
Yes, there is an executive fee. It depends on the state and such. So that's a whole other...
That's another show altogether, boys and girls. Naz, on this one here, we've been doing the Wills Week event here at Al-Ansar now for 3 years. This would, I think, be the 3rd year running. So we're hoping to see you at the event.
No, definitely. Hopefully
with everybody else. It's, I think, in September.
Yes.
Altaf didn't mention the Saturday around the 20th, give or take.
Okay, perfect.
So it's going to be taking place there. Now, folks, if you're listening in, if you're watching the video right now, and you want to ask more questions of Aishvarya, is there an email address that our listeners can use for you? Pop you an email?
Yes, they can. It is legal@aishsingh, AISH, singh.co.za. If you have any questions regarding wills and estates, you can find me there.
Thank you very much. Dr. Khan sends through a comment, says, great interview. Thank you very much for that, Doc. How do you ensure the attorney doesn't steal your money? I think it's a valid question. How do you ensure that the attorney doesn't steal your money? Smack it. Naughty boy. No, but like realistically.
Attorneys are bound by by rules and regulations, by ethics. So ideally, no attorney will be stealing your money. I cannot speak negatively about my profession, unfortunately. So we are bound by these ethics, and we should not be.
Thank you very much for your questions. That's coming through for... Well, that's show related. Thank you very much. Aishwarya, we're looking forward to seeing you at this event in September. Thank you so much for coming through this morning.
Thank you so much for having me this morning.
It's a pleasure.
Quite a pleasure.
So there you go. What's that email address again?
It's legal@aishsingh.co.
AISH.
SINGH.
There you go. Aishsingh.co.za. Done and dusted. Thank you for your time, and thank you for the
so much for having me.
Only a pleasure.